Indeed, at the present time, given worldwide inflation, faltering economies amidst a faltering but persistent pandemic, small, large conflicts, dislocations, displacements of various kinds, progress towards gender parity is stalling. According to the World Economic Forum, which tries to measure this stuff, whereas before COVID, the gender gap was set to close within a mere 100 years, at the current rate of progress, that gap will not close for 132. We're treating Asia as the fulcrum for discussion also, because all too often, those of us here in the West and in the US especially, seem to view this topic through a Western lens, subject to Western solutions. We hope that the conference flips the narrative just a bit, and that narrative that is distressingly common in US law school in particular, when it comes to at least international human rights, we start with the assumption that the West stands as the progressive vanguard relative to those less enlightened elsewhere. In addition, legal Orientalism is, alas, still alive and kicking, especially on this topic. But at this time, with abortion criminally banned from the point of conception, with extremely limited exceptions in 13 of the US states and more than half of US states possibly poised to do the same, the myth of US superiority on human rights or women's rights in particular has been exposed. The US, by the way, is number 27 of the World Economic Forum's gender rankings for 2022, and that was before the Dobbs decision came down, and is, of course, one of the handful of countries on the planet that is not yet a party to the leading treaty in defense of women's equality, the Convention on the Elimination of All Forms of Discrimination Against Women, CEDAW. So the US has never been a model on this subject, but also prominent countries in Asia, to be sure, have not been a model. They don't do particularly well on the Economic Forum's gender rankings. So those gender rankings, just to remind you, are of 146 countries. And if you actually look at them, you can find them on the web. Human rights challenged Philippines does surprisingly well at number 19. Wealthy Singapore takes the 49th spot. Vietnam is at 83, South Korea 99, Japan 116, and India is perilously close to the very bottom at 135. Now, let's just say NYU has been a leader in poking holes at these indices. So I'm not suggesting you take them terribly seriously, but even if you were so inclined, you will see nuances even within the World Economic Forum's data. As you'll hear from one of our panelists, Japan ranks well ahead of the US with respect to gender parity on health and survival of women, number 63 versus the US's 83. But Japan's overall ranking suffers mightily because of its poor showing with respect to women in politics, where the US is at 38, just behind, surprisingly, Brazil, and just above Senegal. Japan is near the bottom with respect to women in politics at 139, just ahead of Vanuatu, dead last at 146, by the way. Of course, these rankings failed, or 145. Of course, these rankings fail to capture the nuance of any of these countries. Japan, after all, is a country where abortion has been freely accessible, but where for a very long time, the abortion pill was not. As some of you may know, the government of Japan just announced that the pill will finally be available to Japanese women, provided their spouses approve. As this suggests, access to reproductive rights is not always seen, as in Roe v. Wade, as part of the right to privacy, or as the CEDAW committee would have it, as derived from women's rights to substantive equality. As all of this suggests, please take the title of this conference with a lot of grains of salt. Asia is a contestable, mythical, meaningless term The countries of South and East Asia, the diverse states, large and small in the Pacific, are a motley group that have little in common. They include established, fragile democracies or authoritarian states, proudly capitalist nations, those that adhere to state-driven capitalism, and those that embrace socialism or communism. Our panelists will focus on the prospects for women in particular countries, but also in sub-regions within them, such as urban versus rural women. They are not focusing on, quote, Asian women as such. Like the CEDAW committee does, if you look at the massively impressive scholarship of all of our panelists, all of them have pushed back against the binary category of women. They are likely to recognize the intersectional discrimination that burdens even those who embrace the single gender binary. And of course, as you've taken a look at the program, we're only examining select issues, forums, and stakeholders. The first panel will examine comparative reproductive rights and distinct rationales for extending or limiting them. The second will consider some of the many international forums where legal rights of women are considered. And the third addresses the activists and groups, that is transnational civil society, that plays key roles with respect to reproductive rights as well as in those international forums of our second panel. Our two keynoters, my current co-teacher, Professor Chen, will start us off, while my good friend of many decades, Rebecca Cook, who literally wrote the book, let's just say she wrote the many books on transnational feminist perspectives, will draw some connections between the panels and tell us where some of us, including those of us who organized this, got it wrong. The conference is, as you'll hear shortly, dedicated to the memory of Tim Gelatt, but I also want to at least informally dedicate it to Rebecca's and my dear friend, the late Karen Knopf, whom we all dearly miss. In the end, we hope that we come out just a bit more enlightened about those who supposedly hold up half the sky are treated here and elsewhere. So at this point, let me turn it over to Catherine Wilhelm, our executive director, who will tell you the real stuff.
Thank you, Jose. I'm Catherine Wilhelm, executive director of the US Asia Law Institute, and I joined Professor Alvarez in warmly welcoming everyone who's here today in the room, and also all of those who are joining us remotely on Zoom, to the 27th annual Timothy A. Gelatt Dialogue on Rule of Law in East Asia. And I want to briefly explain who Tim Gelatt was. So he was a lawyer, a scholar, a teacher of Chinese and international law. He worked in China, practiced law in Shanghai and Beijing in the 1980s and early 90s, which was an exciting time in the development of law in post-Mao China. And since his death in 1994, the law school has held these annual events to talk about international law and particularly human rights law in the context of China and Asia. So that's what is behind this annual event, which we've held virtually for the last few years and now finally in person. I want to thank our co-sponsor, the Birnbaum Women's Leadership Network here at NYU Law, which has helped us to promote the event. And get to my main message, which is to introduce our keynote speaker, Hauser Global Professor Chen Chao-ju. Professor Chen is a distinguished professor and the director of the Center for Human Rights and Jurisprudence at National Taiwan University. We're very fortunate that she is teaching this semester at NYU Law because her expertise and connections have been essential to pulling this event together. Professor Chen writes extensively about feminist jurisprudence, social legal studies, and Taiwan's feminist legal history. She's published numerous articles on motherhood, family, citizenship, constitutional equality, and feminist legal theory in academic journals and books and in popular media. So please join me in welcoming Professor Chen.
Good morning, everyone. I'm honored to have the opportunity to speak at this conference today to share with you my thoughts on the state of reproductive rights in East Asia and how it might relate to the recent development in the US. In the wake of Dobbs, many Americans have come to realize that the US is an outlier in the world. It is one of the 4 countries that are moving toward further restriction on abortion against the trend of liberalization. Lessons can and should be learned abroad. Attention is often directed at Latin America, where country after country has legalized abortion in recent years. But there are also positive developments in East Asia and other Asian countries, most recently in India, where the Constitutional Court has just ruled that an unmarried woman can choose to have an abortion anytime up to 24 weeks. Many are worried that stops will hinder abortion abroad. It might be too early to tell, but I have not yet seen a remarkable growth of the anti-abortion movement in East Asia. In Taiwan, Part B laws have been proposed and the attempts have failed. It is not very well received in Taiwan. So today, I will address the advance of reproductive rights and justice in East Asia, and then discuss the remaining restrictions and challenges with special attention to the dominance of population policy and the shadow of eugenics. The most remarkable development is the South Korean Constitutional Court's 2019 decision. Thanks to the reproductive justice movement's persistent efforts, South Korea's Constitutional Court rendered a decision that deemed the abortion ban unconstitutional, ordering the legislature to amend the law by the end of 2020. No legislation has been passed yet, but the criminal ban on abortion has been lifted on the first day of 2021, turning the abortion landscape in South Korea into a state of limbo. Although the court did not rule on equality grounds, it recognized a woman's right to self-determination. It addressed the enormous impacts of the abortion ban on women in a way similar to Casey, discussing in detail how the abortion ban compelled a pregnant woman to continue her pregnancy and give birth even if she faced the abortion dilemma arising from various and wide-ranging socioeconomic circumstances. And we can also see progress in reproductive justice for people with disability in Japan. The disability rights movement in Japan played a key role in the abolition of Japan's compulsory eugenic-based sterilization and the renaming of Japan's Eugenic Protection Act as the Maternal Health Act in 1996. The movement continued to seek justice for the 16,500 people with disabilities who were sterilized under the old Eugenic Protection Act. Some were sterilized without consent, some with consent, which was only a formality. About 70% of them were women. Lawsuits were filed against the government to seek compensation for the violation of their constitutional right. Several courts found the law unconstitutional without awarding damages. And earlier this year, a court, the Osaka High Court, has awarded damages for the first time. A 2019 law provided monetary compensation to those who were involuntarily sterilized without acknowledging the government's responsibility. And despite the progress in reproductive rights and justice, remaining restrictions and challenges are many. I will address 4: spousal consent, prenatal screening, eugenics, and the pronatalist population policies. Spousal consent is a pressing issue. Both Japan and Taiwan require spousal consent for abortion and voluntary sterilization. And in Japan, married women will also need their husbands' consent to obtain the newly approved emergency contraception pill A Japanese politician, a member of the Social Democratic Party, commented on the government's policy and said that Japan is like in the Middle Age. I guess Taiwan is in the Middle Age too. The spousal consent requirement hinders women's access to reproductive care. It authorizes the husband to control her wife's reproduction. And since Taiwan has legalized same-sex marriage, it is possible, even though we are not sure yet, the same spousal consent requirement will apply to marry the same-sex couple. However, South Korea, Japan, and Taiwan all have a history of abortion being de facto available and accessible under the criminal abortion ban due to non-enforcement or under-enforcement of the law. So the ineffectiveness of the law might have eased the obstacles married women face, but it in no way justifies the spousal consent requirement. As for prenatal screening testing, two of the major issues are sex testing and fetal abnormality diagnosis. We can identify a pattern of differentiated governance, that is, banning sex testing on the one side and encouraging or permitting eugenic testing on the other. In the imbalance of sex of gender ratio, which has been called the missing girls problem, room so large that legal measures have been adopted to prevent sex-selective abortion. In South Korea, the Medical Act bans prenatal sex testing and the disclosure of the gender of the fetus. In 2008, the Constitutional Court ruled it unconstitutional to ban the disclosure of information for the entire pregnancy. And the law has been amended to allow the disclosure of gender of the fetus after 32 weeks, but the ban on sex testing remains in place. Taiwan has a similar legislation which has not been challenged in court yet. And as for genetic testing, the law does not only permit it, but even went to go as far as to encourage it. The legal endorsement of prenatal eugenic screening is a legacy of the past, the dark history of eugenics in East Asia. Justice Thomas invoked eugenics, Black genocide, and sex-selective abortion in China and India in his opinion. And many have pushed back the conservative talks that adopt anti-discrimination rhetoric to oppose abortion. But a look at East Asia invites us to see the possibility of the anti-abortion movement in East Asia, following from recent Supreme Court decisions to support the accusation of abortion as an eugenic practice, and the possibility of the conservative movement in the US using comparative East Asian laws to strengthen the link of abortion and contraception to eugenics. Indeed, in East Asia, abortion was legalized in the name of eugenics and population policies. In South Korea, the criminal ban on abortion was placed with the aim to increase the population after the Korean War in 1953. The Mother and Child Health Act was enacted in 1974 to curb the increase of population, which provided eugenic-based abortion and sterilization. Japan passed the Eugenic Protection Act in 1948 under American occupation to increase the population and prevent the birth of inferior offspring. It included eugenics as one of the grounds for legal abortion and sterilization. The eugenic sterilization clause was abolished in 1996, and the law was renamed the Maternal Health Act. In Taiwan, abortion was legalized in 1984 by passing a law named the Eugenic Protection Act for population control, which remains effective today. And I want to point out the shameful fact that Taiwan, a country that is so proud of its achievement in gender equality, especially its legalization of same-sex marriage in 2019, it is the only East Asian country that regulates abortion by a law with eugenics in the title. And even though some countries have renamed their laws, the idea of eugenics remains alive and well. All 4 Asian countries permit eugenic-based abortion. And in Taiwan and China, doctors are legally obligated to encourage eugenic-based abortion. They are under the legal obligation to inform the pregnant woman and her husband, if she has one, if the fetus is diagnosed with abnormality and should persuade her to terminate the pregnancy. And in Taiwan, prenatal eugenic screening has resulted in few numbers of newborns with Down syndrome. And the idea of a healthy population as the key mark of a strong and modern nation sustains the prevalence of eugenics in East Asia. Eugenics and nationalism inform each other as an ideology that justifies the inferiority of disability and the superiority of the higher class in society. Eugenics function to support a form of nationalism that pursues a strong nation by population control in terms of quality and quantity, by preventing the birth of the unfit. So under eugenic nationalism, it is necessary to enforce quality control to improve the quality of the race. Disability rights movement in East Asia have been challenging eugenic reproductive policies, sometimes hand in hand with the feminist movement and sometimes with tension. So the last, but certainly not the least challenge is pronatalist reproductive policies. Concern for low fertility and aging society have dominated all 4 East Asian countries' reproductive policies. And the most remarkable example of the pronatalist turn in East Asia is China, which officially abandoned its notorious one-child policy and replaced it with a 2-child policy in 2016. Last year, China announced the 3-child policy and a campaign to reduce abortion. And although in other East Asian countries, some of the pronatalist population policies include measures to reduce abortion, they have not yet resulted in significant and severe constraints on abortion. Rather, the more pressing issue is that under pronatalist policies, women are encouraged to become mothers for the sake of the nation. Pro-marriage and family-friendly policies, for example, marriage stipends, child allowance, and paid parental leaves are provided to encourage reproduction. In Taiwan, artificial reproductive technologies are legally reserved for infertile married couples. So it particularly encourages reproduction within marriage. These policies sometimes appropriate feminist languages to legitimate themselves, celebrating motherhood and women's right to be mothers. They often adopt an instrumental approach to use women's reproductive bodies as tools, encouraging women to exercise their rights and fulfill their duty to become mothers. That is, mothering for the nation. Women are considered a means to an end. In the old days, when reducing the population was the goal, abortion was legalized or made de facto available so that women could choose not to be mothers. Nowadays, boosting the birth rate is the goal. Family-friendly policies are adopted so that women can choose to be mothers. To be or not to be a mother is considered a personal choice in the service of the nation. In Taiwan, low fertility is considered a national security crisis. showing how reproduction is considered in the context of a nation's survival. Some have argued for a rights-based population policy or a feminist population policy trying to work within the framework of population policy to pursue reproductive rights and justice. I argue that separating the pursuit for reproductive rights and justice from population policy is the better strategy. Let me borrow Hartman's famous metaphor of the relationship between Marxism and feminism as marriage. The marriage of feminism and population policy is an unhappy marriage in which two become one, and the one is population policy. Rather than staying in the unhappy marriage, the better choice is to get a divorce. So I would say this to end my talk, that is, population control and eugenic nationalism are the primary enemies of reproductive rights and justice in East Asia. And feminist movement and disability rights movement must work together to fight back. Thank you.
So we were going to begin with our first speaker is a remote speaker, one of several women who are heroically sitting up in the middle of the night in Asia to join us live via Zoom. And that will be Feng Yuan. Jess, perhaps you can bring her up on screen. So Feng Yuan is a visiting scholar at the University of Hong Kong and is well known in China and well, globally, I would say, for her long years of activism as a feminist in China. She's co-founder of Equality, which is a Beijing-based NGO. She's a founding member of the Anti-Domestic Violence Network, which was founded in the early years of this century and was extremely important in the movement to legislate against domestic violence in China. And she is with us now. So Feng Yuan, I give you the floor.
So thank you very much to give me this opportunity. I believe my PowerPoint are shared in the screen, so you can see my PowerPoint, right? Yeah. Thank you. Yeah, I would like to talk about in Chinese law, what is the restraints and what is the potentials for women's reproductive rights. So maybe next slide. Yeah. So now I just want to go to the question. Do we have productive rights in PRC law? No and yes. By saying no, I mean the term of reproductive rights are not existed in PRC law. Also, protection as a gender neutral word. But when I say yes, because there are some regulations to recognize and protect reproductive rights and the reproductive needs and the health of women, yeah, especially for women. Also, in China, in the existing law, we have used two terms. Sometimes the law used 生殖 or sometimes use 生育. So 生育健康 or 生殖健康 in English is the same term, reproductive health or reproductive rights. But in Chinese, if you use 生殖 or 生育, maybe have different, not maybe, it's indeed have different meanings, implications. You know, if we only say 生殖, that means that may have more biological model. But if we say 生育, it's have some more implication with social, social meaning. And this is also a tricky sense. In the United Nations document, the Chinese, official Chinese translation from the Cairo Population and Development Conference in 1994, use 生殖健康 and 生殖权利. But in that time, many Chinese scholars, they choose to use 生育健康 or 生育权利 because they want to including more meanings regarding to social and political meaning. So this is, I think, this is also have some difference between these two terms in Chinese. Also, that's only one term in English. That's also the difference. It's also maybe similar with 女性主义 and 女权主义 in Chinese. In English, the same term, feminism or feminist, but in Chinese, they can have different meanings. So I think this is background. So next slides, please. So now I just want to share some regulations on the existing law in China and the status quo returns to reproductive rights. What we have, the word in green color is what they said the state, the government, the state should do what to protect women's reproductive rights. I'm not going to talk about one by one because the time limitation. I just want to pick some of them. For example, okay, let me. For example, I think we have what we have in the law that we have said we have the birth insurance. That means every employers should should contribute a certain of money for each of the employees. So the employee when they have the women employee or a spouse of male employee have maternity leave or deliver a baby, they can get the payment from this birth insurance. And also the state issued maternity assistance to women in need, and also said will consideration for feminine hygiene products and mother and baby products in case of emergency. And also they have the maternity leave and also have the maternity health care in during the baby delivery period, and also including the 4 stages, so-called 经期、孕期 during the period and during the pregnancy and afterwards. And also the government also give women's, women who have lost their fertility will be give the priority to have the rights to live with the children when divorced. So this kind of rights the state protect. This the law also said prohibits certain behaviors such as discrimination and the abuse of women who are childless or have only baby girls, or also during the recreation, and also the state said prohibit divorce from women with pregnancy or abortion in 6 months or a baby less than 1 year old. But what the law did not mention or are very weak is there is no sexual education, especially no rights-based comprehensive sexual education. And also the law did not mention the prohibition of child marriage. The law also did not including unmarried women when they provide the gene ecological service. And also the law is very weak on accountability. So I think this is status quo. So next, please. Next slide, please. Yeah, I think now I just want to talk about the restraints and the potential for the existing laws. Like I just mentioned earlier, I think, yeah, the weakness and what basis. So I think the sex education is a basic right, has a basic element of reproductive rights. And also, some other weakness I just mentioned. I think the potential in the existing law is in the family planning and the population law, said the population work should combine with promotion of women's social status. And also women's law and also this population law also said women have the rights to childbearing as well as the freedom not to bear any child. I think this kind of statements give us potential for realize women's political reproductive rights. So next slide, please. Yeah, now I think all of you know the Chinese law on protecting women's rights and interests. It's undergoing revision. So during the revision, there are very active participation from women, especially the young women, are very active to contribute. So even in the middle of this May, last May, the website of the National People's Congress even cannot continue count how many women's participation, because the meter in this website stopped a few days before the deadline of the public contribution. So so you can imagine how active people participation. So also women's participation in this undergoing revision of women's law, it's one of the highest number by person and by items of the opinions during the last decade. Any other laws who solicit the public opinion. So in this during this revision, women's major concern is in this proposed draft, there is one word, one sentence said sex education, provide sex education. But in the second review draft, these words have been deleted. So now one of our concern is this sex education will be taken or will be kept, and also still not address the child marriage issue. Another one is in the first proposed draft, there is a sentence that the employer should not ask child childbearing willingness during the recruit process. But in the second proposed draft, also this sentence have been taken away. So many women outcry and want to add this sentence again. So now, in later of this month, the People's Congress, Standing Committee of People's Congress will review the draft. So we don't know what will be the result. But also, I think there are some prospects for the future revised women's law. One is have a stronger rights language than previous revisions. For example, I just mentioned, they say they have more regulation for the employers and also for the responsible government department, and also have more clause on remedies, legal liabilities, and accountabilities, despite not concrete and substantive, and also not enough to reach advocates' expectation. And also, we can say another prospect is they have more inclusive language. For example, in the existing law, they said 不能歧视不育妇女, prohibit discrimination against women without fertility. But in the current proposed draft, they said no discrimination against women who have not children, who have not child. So I think this can, have more inclusive meaning. So next slide, please. So so now I think I just want to to say also there is a very limited space, but we still, many Chinese people, especially women, young women, are still very active to try to advocate to change the law, to make it more rights-based language. I think I will stop here. Thank you very much for your listening, for listening me, and I'm looking forward to your questions and comments. Thank you.
So our next speaker or speakers is the research team of Professor Benjamin Liebman, visiting professor at NYU, and is the Robert Lee Professor at Columbia Law School, also director of the Hongyan Zhang Center for Columbia. He's a leading scholar of Chinese contemporary law, particularly with a focus on the judiciary. And with him is his research partner, Columbia Law School student Molly Badurtha. And we're thrilled to have both of them to talk about the research project they're currently doing, looking at litigation, civil litigation in Chinese courts relating to abortion.
Great, thanks so much. It's great to be here and to really have this opportunity to learn from so many experts in the field. So Molly and I are going to be talking about an ongoing, and I should say still very early stage research project on how Chinese courts handle claims relating to abortion. So we're working with a data set of about 20,000 civil cases. Mostly these are divorce cases, some are other intimate partner disputes, in which arguments are made about pregnancy termination, or in which courts mention abortion in discussing the background facts of a case. The focus of our remarks today is on a subset of these cases, about 500 cases, maybe 600 cases we've found so far, in which men argue that their female partners terminated a pregnancy allegedly without the man's, quote, authorization, right? 擅自流产. These cases are drawn from a larger, all these cases are drawn from a larger data set of 42 million cases, representing all cases made public by China's courts from 2013 through the middle of 2018. And this is part of an ongoing research collaboration with Rachel Stern at Berkeley and Molly Roberts and Xiaohan Wu at UCSD. And we're really grateful to them, especially to Xiaohan, who's done a lot of the work with us on generating these data. Rachel and I actually first came across these cases. We'd really no prior idea that abortion got litigated in China, and it's not been written about very much. But we first came across these cases when doing a completely unrelated project on tort litigation, actually, where we found that women were sometimes using the so-called equitable liability provisions of the tort law, the 公平责任条款 of the tort law, to sue their partners for the costs of abortions. And courts were sometimes relying on the equitable liability provisions of tort law to decide these cases. Although you might think of them as contract cases, they were actually being decided as tort cases. And that got us sort of thinking that there was more to examine here and led us down the path that Molly and I are now pursuing. So before Molly jumps into talking about our findings in more detail, and I should say Molly has done the amazing work on this so far, I just want to say a few words on our data and also on why our data may provide a unique opportunity to view how civil litigation may be used to restrict reproductive rights in China. So as we've written about elsewhere, China first required that courts place all cases online in 2014, and there are about 130 million cases online as of this summer. It's probably actually more than that now. But divorce and family law cases are not supposed to be made public. Before 2016, there was some ambiguity in the rules on online publication, and many courts did place substantial numbers of marriage disputes online. I think in our data set, we have about 60,000 divorce cases in our data set from this period. So that's why most of the cases we're talking about from today are from 2014 to 2016. But it also means that the data set we're talking about is likely going to be very difficult to replicate for later years when divorce cases are posted with much less frequency. So that's a bit of an introduction. I'm going to turn it over to Molly to talk about the details.
Great. Thank you so much. Thank you to all those in attendance in person and over Zoom, and to the organizers. It's really such an honor to be here, especially with my fellow panelists, and to share some of our initial findings with all of you. So as Ben mentioned, we are studying male litigants' attempts to regulate their partner's access to abortion through civil lawsuits in Chinese courts. Initially, we were perhaps naively surprised to encounter this phenomenon at all within the Chinese legal system. We've historically conceived of China as having few restrictions on abortion, and as a society in which abortion is generally less stigmatized, given the one-child policy and the state's history of forced abortions. However, our research suggests that private law adjudication is also a tool for controlling women's reproductive choices. As far as we know, the scholarship has not yet focused on this question. So as to the specific cases we're reading, we have identified approximately 530 divorce cases and some more marital property disputes in which men predicate an entitlement on the fact that a partner's pregnancy ended. Specifically, these are cases in which men allege that their partners obtained a, quote, unauthorized abortion, that is, an abortion without the man's consent. Some men even claim that the woman violated the rights of the man's family, particularly the man's parents, by obtaining an abortion. In many of these cases, it is far from clear that the pregnancy termination at issue was even a voluntary choice made by the woman. The women in these cases often argue they suffered a miscarriage, obtained a medically necessary abortion at the advice of their doctor, or even that they miscarried due to domestic violence caused by the man making the claim. In some of these cases, the women suggest that the pregnancy itself is involuntary, which is unsurprising given the prevalence of domestic violence in these suits. Nonetheless, men paint these events, which can be inherently traumatic for the pregnant individual, as willful, unilateral, and destructive choices for which women are at fault and should be held responsible. On the basis of that allegation, men frequently request some form of relief from the court, such as emotional damages, a return of the dowry they paid to the woman upon engagement, custody of any children, or more simply, just a divorce. Particularly disturbing arguments arise from the nexus of these claims with the system of contracting for marriage and dowry payments. Men in these cases argue, occasionally in quite explicit terms, that the woman is contractually obligated through the marriage to be sexually active with the man and provide the man with children, and that the woman's refusal or inability to do so entitles the man to retrieve the dowry he paid to the woman as part of the marriage contract. We have found a subset of cases in which men go so far as to utilize a pregnancy termination as evidence their partners were not invested in the marriage and that the woman was, quote, defrauding the man for the dowry money. These claims are striking not just because they represent such a clear articulation of male entitlement and objectification of women, but they also are explicitly not allowed under Chinese law. A 2011 Supreme People's Court interpretation and accompanying set of guiding cases clearly established that men's claims for damages stemming from a partner's abortion or miscarriage have no legal basis. Article 9 of that interpretation reads, if a husband requests compensatory damages because his wife terminated a pregnancy without authorization, the court will not support such an award. The law does leave open, however, the possibility that reproductive disputes can be grounds for divorce. These laws have not stopped men from arguing violations of various, quote, rights, such as their general reproductive rights, 生育权, their rights to be a father, 作为父亲的权利, their knowledge rights, 知情权, or even their husband rights, 丈夫的权利. To be clear, these rights do not exist for men with respect to a pregnancy. All persons have reproductive rights, as Professor Feng Yuan just discussed. But laws clarify in explicit terms that men's reproductive rights do not entitle them to force a partner to continue or terminate a pregnancy. So what explains the discrepancy between the law and the prevalence of these claims? Our reading of cases suggests that some male litigants genuinely view themselves as entitled to dictate their partner's reproductive choices. Other litigants may be seeking to weaponize reproductive burdens and use reproductive inequity as a tool of harassment when litigation becomes contentious. A lack of understanding of the law may also play a large role here. Regardless, these men clearly believe that their claims are reasonable enough to receive some sympathy among the courts. And women's responses to these arguments have also surprised us. In only a handful of cases do women push back and argue that the claim has no legal basis. Women rarely request the man compensate them for emotional damages or medical costs arising from the pregnancy termination. Much more often, women engage with the man's argument, producing evidence to contest the voluntariness of the alleged abortion. This suggests that some female litigants have internalized the ideas espoused by male litigants, particularly that a woman's unilateral termination of a pregnancy could constitute a wrong. Overall, we see less ambitious advocacy being made on behalf of women, despite the fact that women are represented by lawyers in a majority of these claims, and that the law is clearly on women's sides. And so how do courts adjudicate these disputes? We are still reading cases, but so far, courts' responses seem mixed. In some cases, courts are supportive of women and dismiss the claims as having no legal basis. However, only 8% of cases we have read so far cite the relevant judicial interpretation that protects reproductive autonomy. On the flip side, courts can be quite punitive towards women. We've only found 3 cases that award men emotional damages because their partner obtained a, quote, unauthorized abortion. However, a larger portion of courts seem swayed by some component of the man's argument and attribute significant fault to the woman. For instance, courts are willing to order the woman repay the dowry, even when the legal basis for doing so is unclear or weak. Courts can also be reluctant to order the man to pay half of a woman's medical expenses from a miscarriage or abortion. For instance, one court reasoned the woman was not entitled to compensation on this front because she incurred these medical costs, quote, unilaterally without the man's consent. Finally, in nearly half of the cases we have read, courts simply ignore the man's claim and refuse to address the reproductive aspect of the dispute. Courts' discomfort with respect to openly discussing abortion mirrors the court's avoidance with respect to other issue areas that touch upon litigants' intimate livelihoods and that are considered sensitive, such as domestic violence. So when confronted with fact patterns presenting these sensitive issues, including reproductive disputes and domestic violence, courts will often gloss over the facts and state simply that the parties quarreled over trivial household matters. In 生活琐事争吵. Courts' refusal to step in and safeguard the lawful rights and interests of women in sensitive issue areas effectively delegates the regulation of these matters to the politics of the household and community, which demonstrably in these specific cases can be quite oppressive. So to conclude, in our research thus far, we see men try to weaponize the fact of reproductive capacity against their partners in the course of divorce litigation. Men seemingly do so either due to a genuine sense of entitlement or because doing so might provide some advantage in litigation. While some courts dismiss these claims, others give men surprising leeway to bring these claims to the fore of litigation. Some courts even materially reward men for doing so. Ultimately, even if the court does not grant damages relating to the man's claim, courts allowing the issue to be extensively litigated can legitimize the claim as a tool of harassment. And yet other courts avoid the discussion at all. While avoidance is perhaps preferable to courts endorsing the man's argument, the judiciary's obscuration of salient reproductive politics certainly does nothing to enforce and promote legal protections afforded to women. It arguably allows for patriarchal norms to remain at large and for the legitimation of violence against women. Moving forward in our research, one pressing question is the role that law, legal actors, and legal institutions play in these disputes. So essentially, to what extent do legal institutions reinforce patriarchal norms, and to what extent can legal institutions constrain those norms and instead impose more progressive, equalizing values upon society? On one hand, the 2011 laws precluding these claims are one indication that law can be a source of top-down progress. Yet on the other hand, these cases demonstrate that male entitlement to reproduction and to control over women can still find voice and occasionally recognition within societal and legal structures, even when robust legal protections exist on the books. These cases also confirm a theme that is all too resonant in the shadow of Dobbs and SB 8, namely that private law can serve to restrict women's reproductive autonomy, even in a system in which abortion is legally protected and was in the recent past often encouraged or compelled. As China shifts towards a more pro-birth policy, these cases are a reminder that reproductive choices are regulated not just in top-down policies or laws, but in ordinary disputes and decisions as well. Thank you.
Thank you, and I apologize profusely for being in the wrong room for the last hour because I'm sorry to have missed any moment of this. That was fabulous. I think we have so much to learn in this country from the experiences, not just of Europe and the rest of the world, but specifically of Asia. And our last speaker is Melissa Murray, a star of the NYU Law School faculty, the head of the Birnbaum Women's Center that is a co-sponsor of this event, and one of the leading spokespeople on the whole range of feminist issues. I'm not going to mention my favorite qualification, and that's that she founded and runs Strict Scrutiny, that anybody who's not discovered should definitely check out online. Melissa.
Thank you, Sylvia, and thanks to all of you who have shown up bright and early on a Friday morning, and many thanks to the conference organizers for putting together such a stellar panel. We are really delighted at the BWLN to be a co-sponsor today. So my charge is to, again, bring this into comparative focus by focusing on what is happening in the United States and specifically the ins and outs of the Dobbs decision, and then making some connections between what we've already heard from the panelists and the state of things in the United States. So I am going to first explain the Dobbs opinion very quickly, talk about some of the critiques of the Dobbs opinion, and then relate it back to some of the things we've heard from the other panelists. So as you know, the court on June 24th of this year announced its much anticipated decision in Dobbs versus Jackson Women's Health Organization. This decision was hotly anticipated because, as many predicted, it was the decision that overruled Planned Parenthood versus Casey and Roe versus Wade, once the twin pillars of the United States Supreme Court's abortion jurisprudence. But to lay a foundation, let me step back a little bit and say a little bit about the procedural posture in which Dobbs came to the U.S. Supreme Court. So Dobbs is a challenge to Mississippi's HB 1510, which is a law that prohibits abortion at just 15 weeks. Under the then extant abortion jurisprudence from the court, HB 1510 was plainly unconstitutional, and not surprisingly, it was immediately enjoined by the lower courts, the Southern District of Mississippi, and then the Fifth Circuit. Mississippi then petitioned for certiorari to the Supreme Court in June of 2020. In September of 2020, the court underwent a profound personnel shift because of the death of Ruth Bader Ginsburg, who was immediately replaced in October 2020 by Justice Amy Coney Barrett. After Justice Barrett took her seat on the court, The court again proceeded to consider the certiorari petition in Dobbs. It considered it over 20 times in 20 different conferences, suggesting that this was a question that they were really struggling over, whether or not to grant certiorari and to review this case. Finally, in May 2021, the court agreed to grant certiorari in this case, and they did so only on one specific issue. The issue that Mississippi had asked to be considered was whether pre-viability bans on abortion violated the Constitution. So it's a very narrow question, really asking if the viability line would continue to be a salient marker in the court's abortion jurisprudence. In July 2021, Mississippi filed its first brief before the court, and despite the narrowness of its certiorari petition, in its brief before the court, Mississippi began to take a more assertive and aggressive posture. So not only were they asking the court to uphold HB 1510 and to determine whether viability remained a salient line in the court's abortion jurisprudence, it was now explicitly asking the court to reconsider and indeed overrule Roe versus Wade and Planned Parenthood versus Casey. And I lay that out because it seems improbable that Mississippi's change in litigation strategy is unrelated to the fact of the court's change in personnel. The fact that we went from a 5-4 court, which in 2020 had struck down a number of abortion restrictions, including an admitting privileges restriction from Louisiana, and now just a year later was willing to consider more broadly this question again of whether certain restrictions were permissible and to take up this broader question of whether Roe versus Wade and Planned Parenthood versus Casey were still viable precedents. So on June 24th, we got the answer. Of course, we had the answer presaged in the May 2022 leak of the draft opinion. But on June 24th, we not only got the majority opinion, which was virtually unchanged from the draft opinion that was released in May, and we also got a number of concurrences and a dissent from other members of the court. And what the decision does is effectively uphold Mississippi HB 1510 on a vote of 6-3, and then on a vote of 5-4, the majority overruled Roe versus Wade and Planned Parenthood versus Casey. And the logic was very straightforward. This was a self-consciously originalist and textualist decision, and Justice Alito, who wrote for the majority, noted that because the Constitution does not explicitly enumerate a right to abortion in its text, and because such a right is not deeply rooted in the history and traditions of this country, such a right does not exist. Then turning to the question of whether the court's nearly 50 years of jurisprudence upholding a right to abortion had any say in this dispute, Justice Alito noted that stare decisis, the Anglo-American principle that settled decisions must be respected, was not an inexorable command, and that the court could and should take up decisions that were, quote, egregiously wrong, and indeed they had an obligation in such circumstances to correct the earlier error by overruling those decisions, which the court did. Going forward, though, the majority opinion made a quite unusual step of making clear that its decision was limited to the question of abortion and did not implicate any other rights that might proceed from the fundamental right of privacy or from the court's line of 14th Amendment substantive due process decisions, like the right to marry, like the right to same-sex marriage, and the right to contraception. There were a number of concurrences and dissents in Dobbs, so I just want to highlight some of them. The first is the concurrence from Chief Justice John Roberts. It was very clear in the December oral arguments in Dobbs that the Chief Justice was trying to broker some kind of compromise position that would uphold the Mississippi law while retaining Roe and Casey as valid precedents. And he emphasized in his concurrence that the question that had been accepted for review by the court was very narrow, simply whether or not a pre-viability abortion ban was precluded by the US Constitution. And he emphasized that the majority's decision to go further, to reconsider and overrule Planned Parenthood versus Casey and Roe versus Wade, was a lack of judicial restraint and indeed a question of judicial overreach. Another concurrence was filed by Brett Kavanaugh. He joined the majority opinion to uphold Mississippi HB 1510. He also joined the majority's decision to overrule Planned Parenthood versus Casey. But
His opinion emphasized this idea that the Constitution does not speak to the question of abortion and therefore is neutral on that issue, suggesting that the issue is not at all appropriate for resolution by federal courts, but rather should be reserved to the states and to the people for democratic deliberation. He then went on to forecast something that had already been percolating at the state level, whether or not prohibitions on abortion in some states would preclude individuals from exercising their right to travel to another state with a more hospitable environment for reproductive rights. And he noted that the right to travel would prevent states from prohibiting their residents from traveling to other jurisdictions to seek abortions. He did not note that the right to travel, like the right to abortion before it, is an unenumerated right and not necessarily deeply rooted in our history or traditions as the majority might divine it. He then also reiterated that nothing in this decision imperils the prospect of other fundamental rights. And then Justice Clarence Thomas stepped in to say, hold my beer. And he joined the majority opinion to uphold Mississippi HB 1510 and to overrule Planned Parenthood and Roe. But he maintained that despite the majority's insistence on sequestering the question of abortion from the question of other fundamental rights, that indeed these other line of substantive due process decisions were deeply, deeply flawed. And in fact, they should be reconsidered and corrected at the earliest opportunity. So this concurrence is essentially an invitation to more litigation on the question of same-sex marriage, on the question of contraception, and whether or not the right to privacy continues to be a viable right for protecting certain rights of intimate life. And so again, this is an invitation. It is one that I think is likely to be taken up in not only states that are inhospitable to abortion, but are also challenging the question of what constitutes contraception versus what constitutes abortion, and indeed whether individuals have rights, including the right to marry the person of their choice. Finally, the dissent in Dobbs actually reads like three dissents. This was the dissenting opinion of Justices Sotomayor, Kagan, and Breyer. And it actually read like three separate dissents all smashed together. And they reiterated again, over and over again, some of the same principles, emphasizing that the majority had laid waste to nearly 50 years worth of precedent and had laid a foundation for reconsidering and indeed overruling other precedents guaranteeing other fundamental rights. And they made clear that the majority's insistence on originalism was both selective and itinerant, that this insistence on looking to the history and traditions of this country only yielded this results because only certain histories and certain traditions were actually focused on by the majority, while other histories, other narratives that would undermine the majority's view were actually overlooked. And then finally, they emphasized that the decision would have deleterious effects on the court's reputation and its legitimacy. There are a number of critiques that one might lodge against this decision, and I plan to do that now. First is a question about history and method. This is a decision that is self-consciously originalist. Originalism arose in the 1980s as a response to what were seen as the excesses of the Warren Court. And the idea behind originalism is that in interpreting the Constitution, we look back to the original founding moments, as 1787, or in the case of the Reconstruction Amendments, 1868, and the period after the Civil War when those amendments were being drafted and ratified. But for a self-consciously originalist decision, the Dobbs majority opinion really does cherry pick the history it emphasizes. So it emphasizes certain statutory prohibitions that existed in the colonial period and a common law that prohibited post-quickening abortion, but it ignores a common law history and indeed a colonial history in which pre-quickening abortion, abortions that were undertaken before fetal movement could be detected, were actually fine and were not subject to sanction. And again, it is that history of pre-quickening abortions that Justice Harry Blackmun relied on in his 1973 decision in Roe versus Wade. More fundamentally, in determining that the Constitution has no explicit right to an abortion or even to bodily autonomy, the majority opinion in Dobbs ignores entirely the history and context of the 14th Amendment, which was obviously passed in the wake of the American Civil War and was done with an explicitly abolitionist ethic. So to the extent the Reconstruction Amendment drafters were doing anything, they were trying to deal with the question of enslavement, try to abolish the institution of slavery, and to eradicate all of the vestigial aspects of slavery in American society. So the 13th Amendment abolishes slavery and eliminates the prospect of other institutions that bear the badges or incidents of slavery from arising to take its place. The 15th Amendment grants African-American men the franchise. And then the 14th Amendment and its grant of liberty in its due process clause is explicitly thinking about what distinguishes the prospect of freedom from enslavement. And so when the drafters of the 14th Amendment are talking about what they are doing, they specifically talk about these rights of intimate life. What distinguishes slavery from freedom, they note, is not only control over one's labor, but control over one's family. The ineligibility for civil marriage that was assigned to slaves, the fact that slaves could not retain control over their children and their families are frequently sold away from them. The fact that sexual coercion of slave women was endemic during the period preceding the Civil War, and the idea of forced pregnancy was part and parcel of the political economy of slavery. And so when they were drafting the 14th Amendment, this entire question of marriage, of family rights, of forced pregnancy, of compelled pregnancy, all of this were informing the drafters of the 14th Amendment and underwrote their commitment to liberty. And so none of this is present in the Dobbs opinion, in its recitation of the history, of its insistence on originalism. And indeed, there is an originalist argument to make that there is textual support in the Constitution for such a right. But of course, it is utterly absent in that decision. The Dobbs decision might also be critiqued as being inattentive to the reality of what its impact will be. So the majority in Dobbs purports to return the fraught and divisive question of abortion to the states and to the people for democratic deliberation. What the majority does not mention is that the decisions of the US Supreme Court have actually, over the last 10 years, so fundamentally distorted and disrupted the landscape of democracy that it will be difficult for the people to actually reflect and register their preferences on reproductive rights at the ballot box. Nor does the majority wrestle with the prospect that this decision and its impact will be borne disproportionately by women of color and poor women, particularly Black women who make up a sizable population of Mississippi. The dissent is the only opinion here that even mentions the prospect of Black women, and it does so only glancingly in the context of the disproportionate rates of maternal mortality and morbidity that Black women experience. The majority mentions Black women, but only by implication and only in an intriguing footnote in which it reiterates shibboleth about eugenics. And so here's the footnote. This is footnote 41 of the Dobbs opinion, where Justice Alito notes that other amicus briefs have presented arguments about the proponents of those who seek more liberal access to abortion. And he notes that some of these supporters of liberal access to abortion have been motivated by a desire to suppress the size of the African American population. This idea that abortion access is fueled by a eugenic desire to deracinate particular communities, namely the African American community, is a view that has been circulating, certainly since the 1930s in the context of family planning, when Marcus Garvey argued that access to family planning was a government plot to limit the political power of African Americans. It was reprised in the 1960s and the 1970s by the Black Panther movement and the Nation of Islam, who also heard this call for family planning in the register of diminishing African American political power. Meaningfully, even as men in the Black Panther movement and the Nation of Islam were echoing Marcus Garvey's concerns, women within these same communities were arguing that if the issue was government genocide, the issue was not about widened access to family planning or contraception and abortion, but rather the history of state-sponsored sterilization that Black women had experienced throughout the South and other parts of the country, as well as the unfortunate conditions in which Black women were forced to raise their children. So even within these sectors of the African-American community that were trumpeting this idea of Black genocide and relating it to family planning, there were women in those communities who were insisting that their ability to participate in these movements were dependent on their ability to control their reproductive capacity. More recently, this idea linking reproductive rights and abortion specifically to eugenics has really come through the words of Justice Clarence Thomas. In 2019, in a shadow docket decision in a case called Planned Parenthood, Box versus Planned Parenthood of Indiana and Kentucky, Justice Thomas wrote a separate concurrence, basically arguing that the history of the reproductive rights movement, which he rooted in Margaret Sanger and Planned Parenthood, was inextricably linked to the eugenics movement of the 1920s and 1930s. And he noted that Margaret Sanger had worked with the eugenics movement. And for that reason, he argued, there was a deep history and indeed an origin story around reproductive rights that was rooted in eugenics. And he argued that contemporary efforts to limit abortion, including trait selection laws and reason bans, were merely the state's modest attempts to prevent abortion from fulfilling its eugenic potential. Now, there's a lot you could say about this history. It too is selective and itinerant. And although just Margaret Sanger did work with the eugenics movement, she was not someone who favored abortion. She believed that abortion was barbaric and that surgical interventions would be unnecessary if contraceptive access was widely available. And her association with eugenics was largely born of the fact that the mainstream feminist movement did not want anything to do with her. Although they supported, as she did, the prospect of voluntary motherhood through contraceptive access, they drew the line when she argued that sex should be available for women's pleasure. So the feminists were definitely not into women's sexual pleasure, and they drew the line there. Sanger's association with the eugenics movement really was born of a need to give her movement the imprimatur of legitimacy and indeed science. And in the 1920s and 1930s, the eugenics movement was understood as a scientific movement, as it is today in other parts of the world, which now brings me to the part where I'm going to try and connect some of the threads of the different presentations. It is interesting, I think, at this moment to think about the way in which this eugenics narrative is really taken off in the United States. And Justice Thomas is just one voice in this, but he has been an incredibly powerful voice in shepherding this eugenics narrative and parceling it out both to the lower courts and to other popular movements that have embraced it as well. And indeed, if you look at some of the abortion cases that were decided just before Dobbs, there are a number of references to the Box concurrence and indeed to this notion of abortion as eugenics and the possibility of quote unquote eugenic abortion. It's interesting that in some of these other countries in East Asia, as we've discussed, that eugenics has actually been a platform for expanding access to reproduction. In the United States, it will work in the reverse. Eugenics will be the basis for which we curtail access to abortion on the ground that doing so fosters racial justice. So again, this is going to be sort of an odd amalgam of both US history and its very tortured relationship to questions of race and racial justice. Relatedly, there's much that we could say about the prospect of reproductive rights in the United States in comparison with the other countries we've been talking about this morning. And one of the things that is striking about some of the other societies that we are discussing is the degree to which reproductive rights are understood as embedded in a broader set of supports for the family. So as Professor Fang Yuan mentioned, not only is there access to reproductive rights and reproductive methods of control and technologies, there's also support for pregnant workers, prohibitions on discrimination against pregnant workers. There is robust sex education. There is the prospect of health insurance and prenatal support for those who are pregnant. All of this is utterly absent for the most part in the United States, in large part because our society is rooted in a liberal social welfare model that privatizes the dependency of individual, including their reproductive needs within the family. And so To the extent there is healthcare, it is largely provided through private employer-based health insurance mechanisms. There's more recently some public support for healthcare, but for the most part, most Americans get their health insurance from their employers. And again, there's a broader question after Dobbs about whether or not private health insurers will be willing to fund and subsidize abortion going forward, particularly in those jurisdictions that are less hospitable to it. In the United States, sex education is also a patchwork that differs from state to state, with a number of states, including those states with the highest rates of unplanned pregnancy and the highest rates of maternal mortality and morbidity, having the most impoverished understanding of sex education. On many of those states, the only sex education vehicle that is available is abstinence-only teaching. We also have a liberal divorce regime in the United States that permits abortion on a no-fault basis in every jurisdiction, although fault-based regimes continue to coexist with no-fault regimes. But there are no limitations on whether divorce may occur while one of the parties is pregnant, and that is a marked contrast to some of the other countries that we've been talking about. In the United States, we have famously noted that we are one of the few advanced democracies with no prospect of federal paid leave. That continues. Our only leave program at the federal level is the Family and Medical Leave Act, which offers 12 weeks of unpaid leave. At the state level, there are some states that provide paid leave, but again, these are few. And one of the questions post-Dobbs is, if we are moving toward a pro-life society, whether that pro-life ethos will also undergird an ethic of greater care for those who are pregnant, including pregnant workers and their families during the pregnancy. The United States has, of course, a state-by-state regime dealing with child marriage. And for the most part, child marriages are prohibited, although notably, there are exceptions in every jurisdiction. So those under the age of consent, and the age of consent may vary from jurisdiction to jurisdiction, can still seek to marry as long as they have parental consent. And if they don't have parental consent, the prospect of a judicial bypass is available, and a judge's consent can typically be secured if the minor is pregnant at the time that he or she is seeking the marriage going forward. So all of this is to say that we have, in terms of our public infrastructure, a society that is moving toward pronatalism, but without the infrastructure that would support it. Ben and Molly's account is absolutely fascinating. And I think the comparison to Texas SB 8, that is the Texas Heartbeat Law, that delegates enforcement of the law to private individuals to bring claims against those who are performing abortions or who are aiding and abetting the performance of abortion, is actually quite sound. To the extent SB 8 reflects a kind of public-private partnership where the state has delegated the enforcement of the law to private individuals, Ben and Molly's account actually presages what I think is the next phase in what is happening at the state level. And a number of states have already mentioned the prospect of authorizing fathers under the domain of fathers' rights and men's rights to proceed with civil claims against their partners where their partners have terminated a pregnancy or had a miscarriage that was unilateral. So Yvette Lindgren at the University of Kentucky, or in the University of Missouri, Kansas City, is one of the earliest people to have sort of documented this. But again, it is really animated in this nascent and emerging movement around fathers' rights and men's rights. It's been incredibly active and successful in the domain of divorce and child custody, but now is moving on into the domain of reproductive rights. And it also has real implications for the prospect of assisted reproductive technology and the unilateral destruction of embryos, which has been an issue in the United States for the last couple of years. So again, this is an incredibly rich set of papers. There's lots the United States can learn about where we have been, but also where we are likely going, and lots of ways in which we are moving forward in the footsteps of other societies, but also without some of the supports that those societies enjoy. So I'll stop there. Thank you.
Thank you, Melissa. That was, as expected, fabulous. Shall we give the panelists an opportunity to ask each other questions for a few minutes before throwing it open to the floor? That sounds good. Do any of you have questions of one another? No? Just open it to the floor? Okay. Give us your name.
Hello, my name is Yang Yi, and I come from an advocacy group called LGBT Rights Advocacy China, and I have done a lot of litigations about LGBT issues in China. So my questions about the lesbians and the females who live with their same-sex couples, how to support them to enjoy their reproductive rights, because in some countries, especially in China, the enjoyment of reproductive rights are associated with your marriage status. So that means that if you are unmarried or if you are not allowed married, you cannot to enjoy your reproductive rights. So for instance, in 2020, we launched a litigation about lesbians custody fight in China, and a lesbian couple, they get married they're both Chinese citizens. They get married in the LA and they have twins in LA, and when the back China split up. But one factor makes this litigation so complicated is the twins are American citizens. And why they went to American? Because in China, they cannot access IVF service. It's banned for lesbians and unmarried couples. So I would like to know that in United States or in other Asian countries, is there any cases or any ways that can address this issue? Thank you very much.
Thank you. Anybody want to respond?
So the question of certainly custody rights for non-biological parents has been
Yeah,
one.
I think it's reproductive rights, like because it's in China, it's associated with them. If you get married, you can use
Right.
it. So I would like to hear more about that.
So in the United States, procreation isn't necessarily limited to marriage. In fact, the United States has a growing rate of non-marital pregnancy in recent years, and it's certainly among certain communities. The question of the custodial rights of non-biological parents. So for example, in a lesbian couple where one parent may be both the genetic parent or the biological parent, or one parent is the gestational parent, the question of what that means for the other parent really does depend in jurisdictions on the question of marriage. So after Obergefell versus Hodges, which is the 2015 case that legalized same-sex marriage in the United States, the court in a per curiam decision in 2017 called Pavin versus Smith determined that states could not prohibit same-sex couples from having the same sort of parental presumption that existed in marriage that had previously existed for cross-sex couples. So marriage basically becomes a means of conferring parenthood on the non-biological partner, although many lawyers in the United States recommend that the non-biological partner go further to secure those rights, in large part because it seems like the landscape going forward for same-sex marriage may be cloudy because of Justice Thomas's concurrence in Dobbs. The question of going back to another country and sort of the immigration status and the citizenship status of children born in the United States is a more novel question. And one of the things that we have seen in recent years is the question of whether individuals using ART abroad, like in Israel, for example, is one of the more notable cases. A couple used ART abroad and then came to the United, like the genetic material they used involved at least one donor parent who was a US citizen. And then they had the children in Israel and then decided to come back to the United States. And the question is, are the children American citizens? So that's probably the closest analog that I can think of, but it is a fraught question, one that actually involves State Department policies around assisted reproductive technology, which are really nascent right now. So this isn't something that they have thought about. So this law is changing and evolving and emerging all of the time.
Thank you so much.
Just to add a question, Melissa. Is there anything in the Constitution that would enable a state to prohibit ART to an unmarried couple?
So nothing in the Constitution per se. The Constitution doesn't speak of a right to procreation that has been implied under that line of substantive due process decisions. But I think the Obergefell decision actually could be a huge impediment to limiting ART services to married people, because so much of the Obergefell opinion that Justice Kennedy Rights talks about the importance of marriage for the purpose of family formation for children. So it suggests that childbirth, child raising is best done in the context of a marital relationship. And you could easily imagine a state saying, we're going to prohibit the use of ART by unmarried persons and resting their decision on the fact of Obergefell and its linking of parenthood with marriage.
So I'm going to just push back on that a little bit, just in the sense that in the United States, such a huge proportion of parents are not married to each other. And so the law has adopted to that, and it's and there are not a Supreme Court case, but lots of lower court cases allowing unmarried people to take advantage of assisted reproductive services. But perhaps I heard your question wrong, but it seemed to me that you were asking not just about relations in relation to procreation, but sexual relations. And
Yes, because I think,
protesting that those were limited to people who had somehow formalized their relationship.
I feel like because I think all the panelists talks about are brilliant, but it sounds like they haven't talk about like more straight, but for the lesbians and for the LGBT peoples, how to support them to exercise their productive rights, protect them to have the rights to experience this process.
In terms, again, there is no right to sex in the Constitution, and some would argue that the Supreme Court hasn't recognized a right to sex, or if it has, it hasn't done so robustly as a fundamental right. The case I think is most meaningful on this point is Lawrence versus Texas, which decriminalizes same-sex sodomy and talks about the prospect of sex outside of marriage, but nonetheless in the context of a domestic, consensual, two-person adult relationship that looks very much like marriage. And so, again, to the extent that individuals might claim such a right, I think their success would largely be dependent on whether or not their relationship was understood as proximate to marriage rather than distant from it.
I also will just jump in to say that I think your point about Chinese law focusing on the categories of husband and wife rather than men and women is certainly, or just persons, is really relevant to our research, and the relevant judicial protection or judicial interpretation that affords women reproductive autonomy in our study does only refer to husbands and wife, which require registration with the state, even if two people have hosted a wedding ceremony and stated an intent to marry otherwise. So within the cases in which we've focused thus far, this protection applies for reproductive autonomy. However, once Ben and I begin looking into broader cases for cohabitation disputes or kind of similar intimate partner disputes where the parties are not formally registered with the state in marriage, it's not clear that even these reproductive protections apply. So as Professor Feng Yuan mentioned, the language in the law does not seem to be inclusive at all with respect to this issue.
Thank you. Other questions? Aye.
I have two questions. One relates to the WHO 2022 abortion care guideline. If Dobbs was the low water mark of this year, these guidelines were by far the high water mark. The reason why they're the high water mark is because they move the narrative from the 1994 Cairo decision on the Cairo document on ensuring that you can do what you want with abortion, provided it's not against the law. The 2022 WHO guideline now jettisons that standard and says the international standard now is to comply with international human rights. And it cites CEDAW, it cites a lot of the jurisprudence that has evolved in the past 20 years through the treaty bodies. In particular, it addresses the issue of spousal authorization. And I'm wondering if there's any appetite as these countries in Asia, for example, South Korea was mentioned, if there's any appetite, given these detailed regulations in the WHO 2022 document, to incorporate some of these standards as they move forward to ensure the availability of abortion services. And even in the United States. I know there's some antibodies in the US for thinking about international standards, but I'm wondering if in any of the countries that were mentioned, Korea, Taiwan.
Great question. I should have mentioned this is Rebecca Cook, who we will hear from later in the day. Any of you want to respond?
Yeah.
Chen?
Yeah, thank you, Rebecca. Of course, WHO guidelines are references. And the issue with spousal consent in Japan, actually Japan and Taiwan are the two countries that still have spousal consent. And ever since the law imposed spousal consent, there has been opposition, and feminist movement has been trying to overturn the spousal consent, and of course also citing international law to say that, well, this is against the international human rights. But so far there haven't been much success. So I would say that international human rights law and including WHO guidelines are references, but so far they haven't been able to support and overturn of the law. Let's see that for example, like in Taiwan, we can't even get rid of eugenics in the title of the law.
I'll also say, this is a high water mark for sure. And it contrasts very starkly with Dobbs. In addition to overruling Roe, Dobbs overrules Planned Parenthood versus Casey. And one of the major things that the Casey decision stands for is that the one part of the Pennsylvania Abortion Control Act that was invalidated in Planned Parenthood versus Casey was the provision that required spousal consent to an abortion. And it's largely believed that part of the opinion was written by Justice O'Connor, but whoever wrote it noted that it was suspect because it smacked of the common law principle of coverture and also exposed those who were pregnant to the prospect of domestic violence. And so, it was invalidated on for a number of reasons. With Planned Parenthood versus Casey out of the picture now, there are a number of states that are talking about reviving this idea of spousal consent. And again, a lot of this animates from that father's rights, men's rights movement that really has gained steam over the last couple of years.
Thank you. My name is Aiden McGurr. I'm a first year with the law school. My question is on the Dobbs decision. We see a focus on legislation as opposed to judiciary bodies. And we also see now President Biden advocating for that quite similarly. I'm wondering if you think that can be effective, particularly in light of what we saw with Molly's presentation, where we have that legislation, but even still the judiciary bodies are acting against it. Is the United States basically going down a similar path, or what are there as safeguards now as opposed to there? Thank you.
For me again? I'm actually going to run after this. I have to run to another event and I apologize for my absence. This has been a fantastic conversation. I think there has been, not surprisingly, a lot of attention on the prospect of legislative change, both at the state level and the local level, but also at the federal level. Again, I think any law that is passed, particularly at the federal level, will eventually percolate back up to the Supreme Court. And the court in the majority opinion, talking about the prospect of democratic deliberation, very interestingly, only speaks of democratic deliberation working in one direction, which is to restrict abortion access, not to necessarily liberalize it or to expand it. So, it is notable that Justice Alito's imagination only runs in the direction of stopping abortion, not expanding it, maybe not surprising. And so, again, I think given all of the limitations that the court has in recent years placed on Congress's authority to legislate under certain provisions of the Constitution, whether it's the Commerce Clause or the Necessary and Proper Clause or the Spending Clause, whatever this law looks like, and I think it really depends on how it is drafted. The Women's Health Protection Act is mostly fueled by the Commerce Clause. I think it's going to run into a court that is likely to be inhospitable.
I think we're going to say goodbye and thank you to Melissa.
Thank you for having me.
Hi. One more question. Oh, back. Two more questions.
Well, I'll make it a comment because she's leaving, but I also think that Justice Kavanaugh and Alito and all the majority are going to be a little surprised. They're assuming that they're done with abortion. They're never going to have cases on this again. But we've really only begun to see the fights, the clashes between state laws and federal laws. And so many women now are getting around state bans on abortion by accessing abortion pills, either from other states or from Mexico, from overseas. You've got lots of NGOs that are mailing pills, and it's really hard to police. And, some scholars think that we're going to have huge clashes between federal and state law. Debates about whether you can apply state laws extraterritorially. Can you punish someone who, even in your state, aided and abetted an abortion by getting someone across state lines or by bringing abortion pills in? So I think they're going to have a rude shock when it comes to actually seeing whether abortion has left the Supreme Court. It's going to be back, I suspect, very soon.
That is no doubt right. But what happens when it goes back is, Melissa's probably correct in saying the Supreme Court will not be our helper in the foreseeable future. Leave it to democracy. One more question.
Hi, everyone. So Elizabeth Lynch with China Law and Policy. And just to bring it back to China, I kind of want to follow up with Ben and Molly on some of the findings they have on their research. Namely, I was kind of curious if you're seeing any differences, if the gender of the judge plays a role, or if you can see that at all. I was also curious if the men are also who are making these false claims are also represented by counsel. And then I'm also kind of curious, are you seeing any differences in either the arguments being made or the logic behind the decisions in ethnic areas like Xinjiang and Tibet?
So we've talked about looking at the gender of judges. We haven't done it yet. It's not straightforward for technical reasons, right? You have to use a gender guesser. But we've actually been talking about this, and the data is also, because of its incompleteness, there are also problems with that. So it's a good question, and we thought about it. I don't think we've seen anything on ethnicity. I don't think we have a ton of cases from dominant minority areas. But I'll leave it to Molly on the other two questions.
So as Ben said, we've tried looking into, and we still might look into the gender of judges. And we see a mix of cases across provinces. However, a lot of them have concentrated in populous provinces like Hunan, Zhejiang. So we haven't yet analyzed specifically whether the forms of adjudication or attitudes of justices or anything else are different in areas with ethnic minorities. But that is something really interesting to focus on moving forward. And
lawyers.
Oh, yes, lawyers. And so we've seen that so when men decide to bring these claims and ask for emotional damages or dowry return or anything else, they are often represented by lawyers. Some men also bring them without representation. I would say generally representation of men and women occurs in the majority of cases. So they have lawyers coming into court and helping them formulate and articulate their arguments. However, the rate for men is marginally slightly more than the rate for women. So we haven't seen the presence or absence of lawyers yet, given the depth of our current analysis, playing a major role in whether men make these claims and the extent to which women respond to them. But certainly in the majority of cases on both sides, there is representation.
I'll just say certainly if qualitative research becomes possible again, it's certainly, in our mind that we'd we've been tracking the lawyers in part because we want to talk to them once it becomes possible to do so, if it becomes possible to do so.
Yeah, I just have one very quick comment. I'm Judith Border, based at the University of Vienna right now. And what I just observed is super interesting that the abortion rights movement is kind of conflating with an eugenics movement, because that's not at all the case in European countries and not in Germany or Austria, because eugenics are really demonized and associated with a certain time, and that's the Nazi times in history. And yet I feel it's possible to talk about women's rights to control their bodies and have a right to abortion without being just equated with the eugenics movement. And I feel just adding one perspective to how that has been differently negotiated in different contexts, I feel is important.
Can I ask a question back to that?
Yes, please.
So does your idea of eugenics encompass the decisions made by parents to use prenatal testing and to abort fetuses that are somehow less than perfect? I think the United States has appallingly high rates of that kind of practice. And it's not called eugenics, and it is very different from state-sponsored eugenics, but it's nonetheless a form of eugenics. And is your experience different with that?
So, I mean, of course that exists, but I think there also exists a right to abortion outside of that, and where women just make a choice, to abort a fetus. And that's not a question if that fetus might have a disability later on or not, because I think it's important to disentangle that. But I think it also exists, of course, the practice that you look into.
Of course, it's different
testing.
to have an abortion because you've discovered a fetal defect than because you don't think it's the moral choice for your life in this moment. But is the approbation of eugenics, does it extend to those choices, and how does that play out?
So I think it's the approach is basically that you wouldn't label it under that, but I think that is not my point. I think it's more that you can abort an healthy or unhealthy fetus till 3 months, and you don't have to justify it, and it's not a criminalized practice.
Right.
And I think that's why I think it's important to have, the eugenics discussion as one, but also the right to abortion outside of that. And I think then the debate might become a little bit less entangled, to just view it from that one perspective. But others might see it very differently. But I just wanted to, because I think there has been an abortion rights movement that is not just a eugenics movement.
Yes.
And I think I just wanted to make that clear.
Yes. So we should take a break.